Well, good afternoon or good morning to those who are joining us from the US. Chris Thornham here in London. I'm joined by Anja Lunzer in Munich and Paul England in London. So this is the second webinar in a series, and we're talking about the UPC's place in the European patent system. This is important as the Unified Patent Court doesn't replace the various patent institutions in Europe. It sits alongside them. So we have, for instance, the EPO, national courts. We've got the Brussels regime for allocation of jurisdiction, and we also have the Court of Justice of the EU. So quite a lot of complexity surrounding the interrelationship of the UPC with those other institutions. So before I hand over to Anja, who's going to take us through some of the first points, I thought I should just mention that Denmark has now ratified. So I think that brings the total number of countries up to 5, Belgium, France, Sweden, Denmark, and Austria. And also, a second point is that the preparatory committee has drawn up a list of eligible judges containing over 300 names, as we understand it. Although at the moment, we understand that a formal application process still needs to take place. So some progress since we spoke on the first of our webinars, and I hope that this session on European patent system and the UPC interrelationship will provide further information for you. So I'm now going to hand over to Anja, and I've just moved it through to her next slide, and over to you, Anja.
Thank you, Chris. As we began to explain in our first countdown to the UPC webinar in June, there will be essentially 3 types of national courts in the European patent system when the UPC comes into force. Those in orange are the courts of the EU member states that signed the UPC. Those in green are those EU member states that did not sign the UPC. And those in gray are countries that are members of the European Patent Convention, but not EU members. These cannot join the UPC. In the member states of the European Patent Convention that are not EU member states, the present system of European patents and national patents will continue. Disputes about these rights will be heard in their respective national courts. The same applies to Spain and Poland. But as member states of the European Union, Spain and Poland continue to be subject to the jurisdiction of the Court of Justice. So both green courts and orange courts shown on the slide continue to be subject to the Court of Justice of the European Union. There are 2 other respects in which the non-contracting member states remain connected to the UPC. The first is through the influence on some national courts of decisions of the technical boards of appeal of the European Patent Office, which is shared by the contracting member states of the UPC. This is a passive connection because the courts have no influence over the cases decided. The second connection is the ability of the national courts to refer cases to the Court of Justice. A ruling by the Court of Justice on a case referred by Spain or by Poland is effective across all member states, regardless of whether they are contracted to the UPC. So this is an active connection because the courts decide what questions the Court of Justice will rule upon. As a jurisdictional regime within the EU and subject to the authority of the Court of Justice of the European Union, the UPC is subject to the same European jurisdictional rules that govern all the EU member states. This is in particular the Brussels regulation in its amended form. To fully appreciate how the UPC and the member state national courts can coexist in jurisdictional terms under the Brussels regulation, it is necessary to consider the status of the UPC. There are 2 ways this could work in theory. The first is that the UPC is governed as a discrete court. It is separate and distinct from the national courts of the contracting member states. However, such interpretation would be in contradiction to Article 24, paragraph 4 of the Brussels Regulation. As you all will know, Article 83 of the UPC Agreement allows the revocation of classical European patents, provided they have not been opted out, while in contrast, the Brussels Regulation in Article 24 gives the national court of a member state exclusive jurisdiction in respect of the revocation of classical European patents that are registered in that member state. So if the UPC were a separate court, this would contravene the Brussels Regulation with the exclusive jurisdiction of the national courts. So this cannot be correct. Instead, the UPC must be understood in a different way. We have illustrated this using the black line in the slide. The UPC is present in each and every ratified contracting member state as a court of all member states simultaneously. Hence, a revocation of all designations of a classical European patent in any division of the UPC is simultaneously a revocation in the courts of every member state in which it is registered. So there will be no conflict with the Brussels Regulation. The bird's eye view of the European patent system, as shown in this slide, is therefore one that comprises the UPC, the national courts, the boards of appeal of the European Patent Office, and also the Court of Justice of the European Union. Indeed, the role of the European Union, and in particular the role of the Court of Justice, was a highly contentious constitutional and highly political issue during the final negotiations. The result is that, just as it is now, only matters of union law are subject to referral to the Court of Justice of the European Union from the UPC. It is also clear that referrals to the Court of Justice can be made either by divisions of the UPC's Court of First Instance or the Court of Appeal. When a referral is made, the proceedings that give rise to referral must be stayed until the ruling of the Court of Justice. In practice, matters arising under the European Union treaties in the UPC are likely to be limited to questions of competition law. But there are a number of questions of interpretation that are likely to arise under the acts of the institutions for which the UPC will be obliged on occasions to make referrals. Based on the experience of the national patent actions currently, the instrument that will give rise to most referrals on questions of interpretation will certainly be the SPC regulation. However, other European Union instruments are also relevant to the matters for which the UPC has competence. In particular, these are the regulations implementing the unitary patent and its translation arrangements, Article 10, paragraph 6 of the Directive on the Community Code relating to medicinal products for human use, which is commonly referred to as the BOLA exemption, and last but not least, the directive concerning the legal protection of biotechnology inventions. After long discussions, the UPC attempts to remove the substantive laws of infringement from the European instrument because a referral of questions of substantive patent law to the Court of Justice is thought to be undesirable. Again, this has been quite a political issue, and it is still controversial whether the Court of Justice can rule on infringement matters. It is a feature of the transitional period discussed in our last webinar that there is no apparent limit on actions relating to the same patent being filed in both a national court and the UPC. For example, an action for revocation can be brought against a classical European patent that is subject to infringement proceedings in a national court. And a classical European patent that is subject to revocation proceedings in a national court can be enforced in the UPC. If revocation and infringement counterclaims were to follow in these actions, respectively, the UPC could, in theory, be seized with the same cause of action in respect of the same patent and the same parties as the national court. This apparent parallel jurisdiction and the potential for conflicting judgments is addressed by the lis pendants rules set out in the Brussels regulations. To explain how this works, I am handing over to my colleague Paul England in London.
Thank you, Anya. As Anya explained, the choice of forum between the national courts and the UPC gives rise to the possibility of duplicative actions. This has required amendment to the Brussels regulation in the form of Article 71, which is shown on the slide. This article provides for what are termed lis pendants rules, as Anya said. They are intended to avoid duplicative actions concerning non-opted-out classical European patents being lodged in both the UPC and either a national court of the UPC contracting member states during the transitional period, or a national court of a member state not contracting to the UPC agreement during and after the transitional period. Note that the non-contracting member states referred to as Spain and Poland. So even though these are not member states, they are signed up to the UPC, their relationship with it is regulated under the Brussels regulation jurisdictional rules, including the lis pendants measures. This is important, as I shall explain shortly. But we need to first look at what a duplicative action is in a little more detail. This is because Articles 29 and 30 of the Brussels regulation, which are referred to by Article 71C, provide for two distinct situations. First, under Article 29, if proceedings involving the same cause of action and between the same parties are brought in the UPC and a court of a member state, the court that is not first seized must stay its proceedings until the jurisdiction of the other court is established. It must then decline jurisdiction. Secondly, under Article 30, when related actions are pending in both the UPC and courts of a member state, the court that is not first seized has a discretion whether to stay its proceedings and then, if a party requests it, decline jurisdiction. So staying and declining proceedings to avoid duplication happens when actions concern the same cause of action between the same parties and there is a possibility for related actions. Both of these require some further explanation by way of illustration. So using Anya's example again to illustrate same cause of action and same parties. You've heard that Article 83 UPC Agreement does not prevent an action for revocation being brought in a national court against a classical European patent that is already the subject of infringement proceedings in the UPC and vice versa. So the situation shown in the middle box on the slide can arise. Article 29 of the Brussels regulation is not triggered at this point. However, if there is then a counterclaim for revocation, or as illustrated in the right-hand box, a counterclaim for infringement, Article 29 is then triggered. This is because there is now the same cause of action between the same parties regarding patent A lodged in both the UPC and the court of a member state. At this point, Article 29 requires the court not first seized to stay the infringement action, while the first court confirms that it does have jurisdiction. This is represented by the red no entry sign on the slide. Alternatively, as in this next slide, the revocation action is again lodged in the national court by X, but this time it is followed by an infringement action in the UPC relating to the same patent but against a different party, Y. So the infringement counterclaim that follows in the national court is against X, not Y. The difference in parties is circled in red on the slide. Are these related actions under Article 30 of the Brussels Regulation? If they are, the court not first seized may, on the application of a party, decline jurisdiction over the action. The UPC Agreement says related actions are, quoting, actions so closely connected that it's expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. This in turn raises the question of what circumstances would amount to a risk of irreconcilable judgments. On the broadest interpretation, there is a risk of irreconcilable decisions when the meaning and scope of a patent claim is determined by one way in one court for the purpose of a revocation claim, and another way in another court for the purpose of an infringement claim. However, the language of irreconcilable judgments, in inverted commas, is actually copied from a related part of the Brussels Regulation, on which there are already CJEU cases, namely Roche and Primus, and Solvay and Honeywell. These cases suggest a much narrower interpretation. This is that related proceedings are those in which the parties are not the same but belong to the same group, market the same product, and each infringe the same national parts of a European patent. If this is the correct interpretation, then there are circumstances during the transitional period in which infringement actions against different parties but concerning the same non-opted-out European patent could proceed in both the UPC and the national court of a member state. So a patentee is not necessarily restricted to one or the other court and has options. As I mentioned earlier, the above rules also apply between the UPC and member states that are not parties to the UPC, both during and after the transitional period. Consequently, analogous scenarios to those I've been describing can apply to parallel proceedings between non-contracting member states and the UPC. The implication of this is that the cross-border preliminary injunction that is currently possible in certain circumstances under the Brussels Regulation, as demonstrated in the Solvay case, may be possible between the UPC and those EU member states who have either not contracted to the UPC or not yet ratified it. In other words, a cross-border PI could be obtained, in theory at least, in Spain or Poland, but which applies to markets in the UPC member states. It also means that, until such time as it ratifies, a torpedo action could be filed in the Italian courts in order to delay UPC proceedings. Now, with that thought, I shall hand back to Chris to discuss the relationship between the UPC and the EPO.
Well, thank you, Paul. Certainly I find it quite sobering to think of potential competing courts and jurisdictions in this way and potential torpedoes. But actually there are other aspects of the interrelationship between the UPC and the European institutions that come perhaps earlier and are more common in a lot of people's experiences. And that's to do with the relationship of the EPO, the granting body, and the court system in which those rights may be litigated. So I'm going to address some of those points, and if you return back and look at the slides with the familiar brown, green and blue indicating the different types of courts, clearly an EPO Board of Appeal decision or on a European patent, which might be in the context of an opposition, will then affect those rights across all of these different forums for litigation. So it can impact on national proceedings, whether they're in a non-member state or a contracting member state, and likewise they could be relevant to the UPC. It goes to the very heart of the subject matter in dispute. Now, before we look at the UPC, it's perhaps worth just reminding ourselves of how the national courts deal with this. I know that in Germany, Anya and her colleagues and listeners from Germany are well familiar with national nullity proceedings in Germany, which simply can't be started while there's an EPO opposition that's pending. In France, it isn't quite as black and white as that, but national revocation proceedings are generally stayed while an opposition is pending. And then if you turn to the UK, I think moving through the grades of discretion, I think that the UK and the Netherlands are national jurisdictions where the national litigation is a matter of discretion, whether or not it will proceed while there's an EPO opposition that's pending. So, we come to the big question, what does the UPC have to say on the subject? Well, it allows parallel proceedings in the UPC and the EPO, and it's there for you on the slide, Article 33, 8. And it therefore gives rise to the question, well, if you can have parallel proceedings, how are you going to regulate between the UPC and the EPO? And there's a general discretion there in the UPC articles, there Article 33.10, which provides for stay of UPC actions if a rapid decision of the EPO is expected. Now, we don't really know quite what a rapid decision of the EPO might be, whether that's something within a matter of a few months or whether rapid in the context of the EPO is considered to be a bit more than that. In the meantime, if you think about infringement proceedings that may be going on in the UPC, those could be stayed. And you have to look to the rules of procedure which are set out there. And the wording's a little bit ambiguous. I think maybe that's because it's gone through a number of revisions in terms of the rules. But you see that in the last iteration of the rules, that it explicitly says that an infringement action may be stayed where a decision of the European Patent Office may be expected to be given rapidly. So there we have the UPC leaving it as a matter of discretion. So, it's discretionary. It's perfectly possible to have a patent that is the subject of EPO oppositions, of an EPO opposition, while at the same time litigating in the UPC. And we also know that opposition proceedings can take some time. We also know that the UPC on day one won't actually have a backlog. So one might expect that a decision on infringement and validity in the UPC could be determined quicker than the time it takes for an EPO opposition. And then the question arises, well, if a patentee has obtained a finding that the patent is valid and infringed, can the UPC award damages on a patent that's still potentially going to be revoked if there are EPO opposition proceedings pending? Now, that first question up there, can damages be awarded, is really sort of prompted by some of the experiences in the UK. And one of our rather more colourful judges said, well, you know, public court users need certainty. And in a case to do with floorboards, Unilin, he said, we really shouldn't be waiting for the slowest horse in the race. And he therefore concluded that if you get a final determination on infringement and validity, and there's no further recourse to appeal, because you've run through all the avenues of appeal, then you go on to look at issues of damages and counting up the money. At which point, he was prepared to say that it's too late to return any money that's awarded. And we also had a later case, a much more recent case, to do with seats on airlines, and this related to Virgin Atlantic. And in that case, the inquiry was still running at a point where the patent at the EPO, the scope of the claims had been amended to such an extent that it was now quite clear that things weren't as they had been at the time of the finding of infringement and validity. At that point, the court in England, and this was all the way up to the Supreme Court, said, well, no, it can be a defence to a finding of a damages inquiry if the patent rights go or change so rapidly, so fundamentally at the EPO. But one of the things that the English Supreme Court did at that time was suggested that in the future, in England, what you should do when you have a damages inquiry is you should have a condition made by the court on the order to proceed to a damages inquiry. And the condition should be that if the patent's later held invalid because of a pending EPO opposition, then you return the money. And in that way, a plaintiff, a claimant, with the patent in their hand, is essentially binding themselves to return the money. And the court doesn't have to come back and double back later. It's really a condition. And we see that kind of thinking in the UPC. It's provided there in some of the rules, and those rules have been evolving. And in fact, that language in Rule 118.3 may actually have been influenced by the experiences in the UK to say, no, we're not going to have situations where damages are awarded and then you have to try and unwind it. What we're going to do is provide for a UPC court to make orders that are conditional. And they say, yes, you can go on to have a damages inquiry, but conditional on the patent not being held invalid by the EPO. So you'll return the money if necessary. So that's if the patent's revoked. What about central amendments? Can the UPC stay? Well, yes, it can. Under Article 3310, which I referred to a little bit earlier, and I'll just take you back to that, the general discretion to stay when there's a rapid decision of the EPO, that general discretion is also there if there's central amendment. Just before we came on to this webinar, I was taking another look at that, and I think that it is now expected of a party who is litigating in the UPC that they have to inform the court of any pending revocation, limitation or opposition proceedings. So you see again that the UPC is learning through its experiences perhaps, and it's providing for it in the procedural rules because it's one of those points where we could get into a tangle if it weren't for a careful control of the power and influence of the EPO and the UPC. The two have to work hand in hand. So, the EPO and the UPC, we put there a few points comparing and contrasting some of the aspects of the EPO and the UPC. Clearly, if we just deal with the left for a moment, revocation in the EPO covers all the designated states. It is less structured and less control, one might say, than litigation court proceedings. And as a result, it's relatively inexpensive. The big downside, I think, from my perspective anyway, as a litigator, is that you have to lodge your opposition within 9 months of grant. And you don't always know. That is, to me, a big disadvantage. Auxiliary requests in terms of amended claim scope, etc., well, I see that as useful. But you've got there at the bottom in bold and capital something that's really quite a problem, I think, certainly from a litigator's perspective, is the time it takes for an EPO opposition. And if you go back and you think about comments from, say, Mr. Justice Jacob, he was saying that parties need certainty. They really want to get a resolution because they're trying to conduct their business. and that the court shouldn't always be waiting for the slowest horse in the race. Well, we have the UPC, and that does give us some of the advantages that we might be looking for. I mean, we could deal with these almost in reverse. I think that speed, if you look there, it's put there in bold and in capitals, that it's fast in the UPC. Now, we put 2 years there, and that's our expectation, that within a couple of years you should be getting a resolution of issues of validity. After all, the UPC, when it opens its doors, will have no backlog, none at all. So that first invalidity action could be dealt with relatively quickly. We'll have central divisions with specialist technical personnel, technical judges, all ready and waiting. We'll have auxiliary requests and those sort of things which are comparable to EPO opposition. But I think also the fact that you can lodge at any time, that's remarkably flexible and powerful for any party who, for whatever reason, finds that they're presented with some European patent rights that they find themselves bumping up against. The flip side of that is that in the past, once you got through the opposition period, you knew that you had rights that were, well, dare I say it, strong. It would require some effort by a party to navigate around them. But now, once you get your European Patent Office grant decision, and for the sake of argument, there is no opposition, you can't assume that those rights will be respected or unchallenged, or will go unchallenged. The UPC is going to offer a forum which we expect is going to be really rather active when it comes to revocation actions. It will be more structured, there will be more control, and there will be more expense. But compare that, a revocation action in the UPC, to a revocation action in each country, one after the other. That really is expensive, and, well, it doesn't really offer you that much control, because you know that you're in the hands of different judges and different tribunals. This is one of the reasons why a lot of patent owners consider the UPC is an opportunity, but it's also a risk that your European rights are all there, all your eggs are in one basket and may be challenged in the UPC. And if, of course, that patent is revoked, then it's going to cover all of those member states that are ratified and that are parties to the UPC. So, we can see, just going back and thinking about the various different topics that we've talked about, allocation between different, the relationship with the Court of Justice and the EU is one that will continue and will throw up its own areas of complexity. Parallel proceedings between the UPC and national courts will also generate complexity. But if I were going to raise one topic which I think will definitely, almost on day one, throw up interesting new developments, it will be the fact that parties who've missed the opposition period can centrally attack in the UPC with the potential to revoke across all of the member states. Well, I feel like I've probably talked enough. There's Paul with me, and there's Anya also in Munich. I think that we covered the topics that we wanted to address today. So, thank you ever so much for those who attended, joined in the webinar today. If you do have questions, we're more than happy to deal with them after the webinar. And another thing to mention is that the slides and also, I think, an audio of the webinar will be available, and we can make sure that those who've attended can have a copy. So with that, thank you ever so much for joining us, and hopefully hear from you soon.